Good afternoon, class, or good morning, whichever and wherever you are. I decided to go for this recording so that it will give us more possibilities in case my internet or your internet would not be fine, especially just after this typhoon, Rolly. So I hope you are all in good shape. And let's just continue to pray for those who have been affected by this devastating typhoon. So I left you with a few slides where I give you an assignment, and I have checked your assignment, and most of you did well. Well, I will just run through those slides before I go to the next set of slides. So remember, we began with persons in the church and the Code of Canon Law of 1917, that means the first Code of Canon Law, has included actually what we call moral person. So moral person, and that's also included in the Code of Canon Law in reference only to the Catholic Church or to the Apostolic See. So when you go or when you would have gone to the canons on moral persons, you would have seen that there, Canon 113, paragraph 1, the Catholic Church and the Apostolic See have the status of a moral person that by divine disposition. And then paragraph 2 there, in the church, besides physical persons, there are also juridical persons, that is in canon law, subjects of obligations and rights which accord with their nature. So you've seen that in the slide, physical person and juridical person. You are a physical person, I am a physical person, and I went by classification of physical persons, the infants, children, in reference to age of reason, because when you talk of an infant, you're talking of somebody who is below 7 years old. When you reach 7 years old, that means you have achieved the age of reason, which is also otherwise known as the age of discretion, which is also the way civil law would have defined an infant. And just to put things together, an infant is also somebody who's incapable of personal responsibility. So you would imagine that somebody who is suffering from Down syndrome would be considered an infant, no matter how old he or she would be. And then we have minor below 18 years old and major above 18 and above. And one good example of that is, of course, marriageable age in Philippine law, which is also what the church here observes, is of course 18 for women and 21 for men. Of course, now they say, the late Archbishop Cruz, I asked him, would you allow for an 18-18? That means 18 for the girl and 18 for the boy. Yes, that's allowed in the Philippines. So you have what canon law there indicate for has indicated for marriageable ages 14 for women and 16 for men. Of course, that is in other cultures, unless otherwise the Bishops' Conference has stipulated something which is of the particular place, and that for this particular place called the Republic of the Philippines, we observe that the marriageable age is 18. And then you have juridical persons. You have to understand that very well. A juridical person is not a natural person, it's an artificial person. Immediately you have the Ictc, which is an artificial person, and it's juridical because it is constituted by a competent authority for an apostolic purpose. So it's not just for anything that it is constituted, it's for an apostolic purpose with a capacity for continuous existence, meaning its nature is perpetual and with canonical rights and duties. So Ictc is a juridical person, the OFM Philippines is a juridical person, provinces of the different congregations are juridical persons, and diocese is a juridical person, and the parish is a juridical person. So it's an artificial person, and you have to take note of this. If you go to the canon which brings us to the the local ordinary of a diocese, the local bishop of the diocese, not the auxiliary bishop, but the local ordinary, the bishop of the diocese. Canon 393 says, in all juridical transactions of the diocese, the diocesan bishop acts in the person of the diocese. So the person of the bishop, who is a local ordinary of a particular diocese, he is not just a physical person, he is also a juridical person, because he represents, he acts in the person of the diocese. He is a person of the diocese. So that makes him a juridical person. So just take note of that. The same way as the Holy Father is the Roman Pontiff, the Pope. So juridical person, because they act in the name of, or he acts in the name of the Roman Catholic Church. And we went into the next slide, which is just going by the hierarchy of documents we have in the church. So general decrees and instructions. So laws, of course, laws, that would be the first of the documents of the church, because laws is where legislative documents are contained. And then you have administrative norms. Administrative, when you say administrative, you have an administrator. An administrator is a competent authority, and a competent authority at that who has executive powers. So administrative norms are like laws, but they are contained in administrative documents, which are identified as two: general administrative decrees and instructions. And the general administrative decrees are also two kinds: general executory decrees, decrees which are addressed to those who are going to execute it, and general administrative decrees. So general administrative decrees. So all these three documents, laws, administrative norms, general administrative decrees, are binding. Binding. They bind those to whom they are addressed to. They are also what you call non-binding documents. So there are those that are intentionally drawn up and issued without any force. They have no identifying labels. They are sometimes referred to with various titles like guidelines, pastoral guides, or pastoral statements, etc. Now, to say, in that sense, by classification as non-binding, it is not to say you make a document that does not bind the people. Of course, they do bind the people, but not in the same way as those that we have mentioned, because those that we have mentioned have what you call the force of law. Okay, so this one is without any force. So like pastoral statement of the parish priest, pastoral statement of the bishop. Now we go into the singular administrative decrees. I would have liked that if this would have been interactive, because you would have said something and I would have responded over certain things. But the point of going through the singular administrative decrees is, of course, for you to know what these terminologies mean. And there will be certain terminologies that we would encounter every now and then. So singular administrative decrees, and that's in Canon 35. One who has executive power can issue a singular administrative decree, a singular administrative act rather, which comes to us through a decree, Canon 48, through a precept, Canon 49, and through a rescript, Canon 59. So decree as a singular administrative act. Singular, it is addressed to a singular physical person or singular juridical person. Singular. Administrative act, because one who issues it is one who has executive power. Of course, you see later on that also somebody with legislative power. But to put it in more generic terminology is one competent authority. And then an act. So decree. Decree, as I mentioned in the slide, is not a favor but a provision that does not presuppose that a petition has been made. Now, for example, I mentioned there an appointment. You're appointed director of the Office for Disaster and Rehabilitation, meaning it's a new office. You did not ask for it, so it's not a favor, but it's a provision that is given. So it's not a petition because it is a provision that is given, okay, like an appointment. So that's a decree. A precept, on the other hand, is an obligation that is directly and lawfully imposed on a special person or persons to do or to omit something, especially in order to urge the observance of a law. Its nature is imperative. So you have a precept, like you would say precept is a command, and command is imperative. One good example of that is, of course, when the bishop issues a precept of suspension of a priest from certain faculties. So precept, singular administrative decree. And the third that is mentioned by the Code of Canon Law, Canon 59, is a rescript. So a rescript is a favor. A decree is not a favor. A rescript is a favor granted at someone's petition, at someone's request, which by its very nature can be, what we say their privilege, can be a dispensation, and can be other favors. I deal more with what a rescript is because there are many classifications there. When you say it is subject to the following acts, because we said it is a favor. So there is a petition. And because there is a petition, the petition should come with certain reasons. And after the reasons, petition with the corresponding reasons, then this is being assessed by the competent authority. And then the competent authority issues the document which the petition, whether the petition is granted or denied. But for the validity, the reasons cited are important. So there are two types of reasons, and you can apply that for any situation or case where you would need reasons. For example, one of the type of reasons is motivating reasons or principal reasons. There has to be a motivation why, for instance, you want to apply for an exclustration, extra clausura, outside of the cloister, meaning outside of the institute. You are a passive member because you want to, kind of an experience of a discernment process whether I continue the journey or not. So there must be motivating reasons why you apply for an exclustration. And of course, there are also secondary reasons, which you can say impulsive reasons. Of course, a certain reason comes also with the feeling of the person. Maybe you're angry with your superior, but that will not be a reason for which your petition will be granted. There must be a motivating reason, a principal reason. Can you say, I'm no longer happy in my community? Well, that is impulsive reason. That's a secondary reason. So what makes you unhappy? Maybe I need a clearer understanding of the path of consecrated life. So, but altogether, that is still very general. You have the motivating reason should be if you want to put it clearly, that should be a reason to convince the one who issues the document. So the rescript. There are, of course, defects in describing the reasons, but especially the major defect is, of course, when they look at the sincerity of the person who is asking for a petition. And the sincerity of the person can render the rescript valid. The lack of sincerity of the person can render the rescript invalid. So one of the what I call their very the terminologies that are legal and very technical is, of course, there is what they call an obreption, or a false statement, and a subreption. A subreption is when you are withholding the truth. So you know, experiencing or being exposed to a lot of documents that speak of reasons. This will make you distinguish immediately if the person is withholding the truth or he or she is speaking the truth. One type of arrest script is, of course, privilege. A privilege is a favor granted for the benefit of the persons to do or omit something in the law, as it is stipulated in the canon. So that's a privilege, as stipulated in the canon here on arrest scripts. And when you say to do or omit something in the law, there's what you call favor contrary to the law. There's also what you call favor apart from the law, as the canon here has indicated when it talks of privilege, Canon 76. A favor given by a special act for the benefit of certain persons. It can be granted by a legislator, because we said arrest script is granted by somebody with an executive authority, but it can be granted by a legislator. And as I mentioned here, privilege, favor contrary to the law. There is a law, there is a stipulation, and everybody is supposed to observe that. And for this particular favor, you ask the competent authority to be given the privilege not to observe it. So every Sunday, there's a kind of an obligation to observe Mass. And in many parishes, of course, the obligation is to observe Mass in your parish church. But there's a petition. The petition comes from a mandated organization asking that every fourth Sunday of the month they assemble in the cathedral. But the standing policy is, on a Sunday, we're supposed to be in our parish. We're supposed to be observing the Sunday obligation in the parish. And if there are meetings, there are to be meetings in the parish. So you're not supposed to be traveling. One of the things that I was hurdling with many mandated organizations back in Zambia in my mission, lots of traveling, and it should not happen on a Sunday, because, for example, you schedule a PPC, a Parish Pastoral Council meeting, and then one congregation is out for a Kuria meeting. Legion of Mary is one of them. So of course you will have to choose a Sunday where there is no Kuria meeting, but there's also another Kuria meeting for another organization. So this is a favor contrary to the law. So a petition of a diocesan association to assemble every fourth Sunday of each month in the cathedral, for instance. Now once it is granted, that becomes like a privilege for that particular mandated organization. There's also what you call favor apart from the law. So there is a standing policy, there is a standing stipulation, there's agreed upon law, if you like to say it, but there's a petition that on top of it they be granted this. For instance, an example I always use is a petition of a lay leadership of a third order, where its members may wear the habit of the first order at certain gatherings and for their burial. So there's a violation, because this particular law of wearing the habit is only reserved to the first order of that particular congregation. Maybe I will just use, for easy explanation, Franciscans. And you have the first order Franciscans, you have the second order Franciscans, that belongs to the contemplative sisters, and you have the third order Franciscans, those in the active ministry, or the third order, sometimes referred to as the secular order. Now, a petition comes from the lay leadership of this particular order, meaning they are lay people of this third order, that when they die or when he dies, that he may wear the he may be granted, or they may be granted the privilege of wearing the habit of the members of the first order. Now, once that is granted, that becomes like a favor apart from the law. There is already a standing there's already a standing policy on that, and then you add something more. So precisely why in many third order institutes, they have all these privileges. When they die, they can wear the habit of the first order, or for women, they can wear the habit of the second order. A rescript, which is a singular administrative act, can be a privilege. Another type of rescript is a dispensation. So you can always say, somebody who receives a dispensation can always say, I haven't received the rescript. So dispensation easily, you imagine somebody who wants to leave the priesthood for what I say, gravest of reasons, with such motivating reasons or principal reasons. Now, once that is granted, he is given a dispensation from the observance of the vow, of the particular observance of the obligation of the celibate life. So, of course, one who is dispensed from that can get married. Okay? Now, before, in the old law, of course, one who leaves the priesthood is granted the status of lay cessation. But that has changed in the meantime. So, once you leave, you will be granted a dispensation from the obligation of celibacy, because you remain a priest forever. You remain a priest forever. So dispensation has to be understood in many ways. But let us say, by general definition, it's a relaxation of the law's rigors on account of a necessity of circumstance, or an exception to the law given for a spiritual good of the faith and for reasonable causes. So, the word dispensation, of course, has many uses. If you are familiar, in French, we call like a clinic a dispensary. Medical use, like a dispensary. The priesthood also, you also use the word dispenser. The priesthood as a dispenser of the sacraments. You have also the dispensing machine where you go to get something, or a water dispenser. Roman law used it in terms of release from the law. So you are like released from prison because you're given clemency. But there's also what you call in history the broad dispensing power of bishops. Yves Chartres, for instance, thought that the bishop should dispense the people whenever they secure spiritual goods as an act of mercy. So you can dispense the people. Like, for example, somebody comes to you during Lent, and for a very serious reason, will come to you and say, Father, can you dispense me from the obligation of the law of abstinence, because my daughter is graduating, and I really want her to I really want to give a party for her, and so on. Or, Father, can you dispense me from this Sunday, because I'm going for an overtime. So, of course, it's nice to get Christians who with much respect for the laws of the church come to you for that. That means they come to you and you use your dispensing power as parish priest. And also, dispensation presupposes an obligatory bond which relaxes from a just cause. Okay? So, dispensation from ratum et consummatum marriage, which only the Holy Father can grant. As a relaxation of the law, it can also be understood as a wounding of the law, which looks like an exception to the law, similar to dispensation from procedural formalities. But of course, not certain procedural formalities. There are just simply there are exceptions to the law, for which you cannot give a dispensation. So I mentioned there in your slide that there is what you call exception to the law in what is constitutive according to the law is actually difficult. So when it speaks of what is constitutive of the law, rarely can that be dispensed. Like you cannot dispense a religious institute from not having constitutions, because any association for that matter needs its statutes, needs its constitutions. You cannot also dispense an entity now in the church from not having a finance council, because the law is very strict on that. Finance council for any association, any religious institute. Or you hardly could dispense marital case from not having a defender of the bond. So because a defender of the bond treats causes pertaining to marriage. So when you apply for an annulment of marriage, there has to be a defender of the bond, because he plays a very important role in upholding the sanctity of marriage. Or the presbyteral character of a parish priest. Of course, it cannot be parish priest if he does not have the presbyteral character. So you cannot dispense that. But there are other elements, of course, for which you can dispense something. What I want to say is there are certain laws for which its constitutive elements cannot be dispensed. So in the liturgy, we say to the extent that liturgy comprises constitutive law, dispensation is not possible. But to the extent that rubrics belong to the disciplinary laws, yes, you can dispense them. So dispensation, we may have to explain that with some basic principles. It is given for the spiritual good of the faith and for a reasonable cause, but never to damage. Even though the bishop has every power to dispense, he is not free to change the essential purpose and character for which he is dispensing, or for which he is allowing the exception, for which he is allowing the relaxation of the law. And all juridic acts and institutes witness to the church and her wholeness. And for this reason, if there is dispensation, the wholeness of the particular entity and the witness to the church must be protected. The Holy See recognizes that it cannot dispense other laws apparently from episcopal orders, from the irregularity of abortion, from the impediment of consanguinity. I suppose you know the word consanguinity, but that also belongs to the discussion here, consanguinity. When you talk of consanguinity, sangue, blood, so consanguinity, blood relations. You cannot marry your first cousin. So there is an impediment, a deriment impediment in marriage when it comes to some consanguinity, up to the 4th degree of horizontal line. Father, mother, brother, sister, aunt, nephew, and then first cousins. There may still be exceptions, and true indeed, exceptions from procedural laws, because procedural laws assist in the protection of rights, and neither from penal laws. You cannot practically dispense from penal laws, because penalties, in a sense, look into the spiritual conversion of the people of God. So there may still be exceptions, and true indeed, but not probably I should not say not probably, but not in procedural laws, especially those that point to where they can assist in the protection of rights, not in penal laws, because penal laws look into the spiritual conversion of the people of God. The granting of a permission, faculty, indult, which we shall hear later, and absolution is not contained in a notion of dispensation. Again, the granting of a permission, faculty, indult, absolution is not contained in the notion of dispensation. So I wrote there in the slide, permission is what you call licentia. It is the faculty of doing or omitting something which is permitted not in an absolute manner but conditioned by the consent of the lawful authority. So you're granted the faculty to do this. For example, during the year of the laity, there was in many dioceses the permission to grant our lay leaders, or what you call the Eucharistic ministers. They were granted the faculty to do the rite of burial, or they can do the blessing of a church. They can do a house blessing, but after the year of the laity, that was lifted, and of course some Eucharistic ministers understood it as already a permission, a perpetual permission. No. So there can be a faculty of doing or omitting something which is permitted not in an absolute manner, but depending on the consent of the lawful authority. So indult, I will explain that as you have seen towards the end of the slide. It is designated as a special favor given for a determinate period of time. It's neither perpetual like an indult of a marriage dispensation. And then you have other administrative acts, other favors, and you have what do you call faculty. Now faculty, of course, you have the faculty of law, faculty of the College of Law. You have that is in reference to the teaching, the teaching faculty. But here you have, by definition, faculty is an ecclesiastical power or authorization necessary for performing lawfully an act of ministry in the name of the church. So there's what you call jurisdictional faculty, is a power of governance. There's also what you call non-jurisdictional faculty. It simply authorizes you. It gives you an authorization, and just like that, a simple authorization. So jurisdictional faculty is, of course, restricted. That's why I told you it's jurisdictional. It has a power of governance, especially the governance that is delegated. And when you call what you call in Latin as delegated authority is abomine. Omine. It's from one person to another. The competent authority to another person, subject to him. So that's jurisdictional. And the Code of Canon Law, immediately when it talks of faculty, it immediately brings us to, like for example, the Canon 9:9. Whoever habitually lacks the use of reason is considered as incapable of. Oh no! I'm not referring to that. Sorry, I'm referring to Canon 132. 132 habitual faculties. I'm referring to habitual faculties. The discussion on faculty falls under power of governance. So you have Title 8, Canon 129, explaining the power of governance, which is reserved to those with sacred in the sacred order. And then you have 130, which explains, of course, power of governance exercised for external forum and also exercised for the internal forum, the forum of conscience, the internal sacramental forum, which of course comes, for example, in the sacrament of confession, or even spiritual direction. And then it goes immediately to what you call here habitual faculties. which says Canon 132 are governed by the provisions concerning delegated power. So just to explain it a little bit more, as I mentioned in your slide, habitual faculties are species of privilege, like a favor. It's granted to you personally. So it being a favor, it also is a singular administrative act. So it's a species of privilege, like a favor, something granted to a person. And habitualiter. So habitual. It is when you talk of it being habitual, of course you're talking of it, you can use it regularly. You can use it as you should be using it. And then habitual faculties are governed by delegated power. So again, abomine. They are not, when you say abomine, they are not faculties of office. So delegated power, that means they come by the concession of a competent authority. Delegated, they can also be delegated by law. Delegated by law. What's an example of that? Did I not mention that if it is delegated by law, it's a faculty you can exercise? For example, when you have to administer this sacrament in danger of death. There's even a canon where it says here 883 and 883. 883 mentions, for example, let me just go to that. Let me look at it. 883, for example, says the following have by law the faculty to administer confirmation. Of course, first in the list are those equivalent to diocesan bishop. And in respect of a person to be confirmed, the priest who by virtue of his office or mandate by the diocesan bishop baptizes an adult, delegated by law. There's also what you call, as I mentioned, in respect to those in danger of death, the parish priest or indeed any priest can do that, can confirm in danger of death. So that is habitual faculty delegated by law. Delegated abomine, I mentioned that, and then I made mention of what I said here. Habitual faculties refer to some state or capability, it being habitual, habitualiter, habitualis. It being habitual is of course ongoing. It does not refer to something that occurs or may be used only once or in a specific instance. More to habitual faculties. Habitual faculties refer to some state of or capability that is ongoing. The priest who has the faculty to hear confessions habitually may use it regularly on an ongoing basis, unlike if this were a grant of a faculty for one or several occasions only. A general delegation to assist as marriage is a habitual faculty. Canon, let's go to cite the canon there. Canon 1111. Okay? Canon 111, which stipulates that as long as they validly hold office, the local ordinary or parish priest can delegate to priests and deacons the faculty, even the general faculty, to assist as marriages within the confines of their territory. You can imagine somebody who is occupying the office of associate pastor. So for that reason, he can officiate marriage in that particular parish. Other faculties are for special acts of the power of governance, like granting dispensation and remitting censures. Other faculties authorize lawful performance of non-jurisdictional acts. So I told you, non-jurisdictional faculties like what? Giving a blessing or celebrating Mass twice a day, because we are actually only given the faculty to celebrate Mass, once a day. So you can be given a faculty to celebrate Mass twice a day. More on habitual faculties, of course, is when you talk of it, there are implications in reference to, for instance, confession, the validity of confession. Canon 966, paragraph 1. What do you have there in Canon 966, paragraph 1? For the valid absolution of sins, it is required that in addition to the power of order, the minister has the faculty to exercise that power in respect of the faithful to whom he gives absolution. Okay, parish priest. Once revoked, of course, faculty is lost on a case-to-case basis. So again, when you talk of a precept, when you talk of you being suspended, and so you are suspended from administering this faculty. There's an interesting implication still of a habitual faculty, a jurisdictional faculty that is reserved to you for a particular in the exercise to a particular jurisdiction. So there's what you call there in Canon 144 common error. 144 common error. What is common error? I wrote there factual, legal, where there is probable doubt. Traditionally, the principle is in the interest of the community. So that's why when it says ecclesia supplet, the church supplies. What does the church supply? So the church supplies the power as a kind of a transfer of power of governance. Maybe you observe this jurisdictional exercise of the sacrament of confession, and you arrive at a parish for which you have no jurisdiction, and there is a community in need. There are children who are waiting for their parish priest to receive the sacrament of confession, but the parish priest has not arrived, and 2 hours has lapsed. So you're kind of, and then you saw the catechist saw a priest there who probably is playing or is playing basketball, and this is a vacationing priest, friend of your parish priest, and you attempt to invite the priest, and finally you're able to convince him because there is a community in need. So what is the error there? When you talk of a common error, you're actually talking of the priest has no faculty to hear confessions, but because many children want to confess, and he is sure that in a given situation people will think that he has jurisdiction, although he does not have. Maybe catechist thinks that he has jurisdiction, and so for that reason, because you are a priest, you attend to the needs of that particular community, and so the church will supply the faculty. So that's the reason why it's called ecclesia supplet. The church supplies the jurisdiction. The church supplies the power as a kind of transfer of power of governance. And remember what I told you as an assignment was the difference between privilege and faculty. Some of you got that very well. Saying that privilege is a favor for the benefit of determined persons, while faculty is not a favor but an empowerment for an act of ministry or administration. So for that you're making sense. Faculty is a juridic empowerment, like some of you said. A privilege is not a form of empowerment to act. So it, of course, it being a privilege, and some of you said, of course, very well that a privilege is presumed to be eternal, while faculty is not. Okay, a privilege may be given to a juridic person. Remember, I told you it being a rescript, it being a singular administrative act. It is singular because it is given to a singular physical person or to a singular juridical person. So it may be granted to a juridic person, a privilege, but faculty, it being faculties abomine, are always granted, delegated to a determined physical person and not to juridic persons, and so on. Most of you got that right. And the end of this set, the end of this set of slides is, of course, I put there an indult. Because why? Because it's for me good to know that you have to understand that terminology. Somebody might ask you what an indult is, and you might be asked, well, you did not learn that in your canon law. Well, you learned it in your canon law, but probably you were absent during that time. No, indult is a generic sense of a rescript. So generic sense of a rescript, used mainly in a sense of a permission or authorization. For example, an indult to leave religious institute. Now, by the way, when I counted all the canons here that use the word indult, most of the canons refer to canons related to consecrated life. So you have canon 684, number paragraph 2, 686, 687, 688, 691, 692, 693. If you get one from among them, just for example, 687, just to read one, because I said there are 16 canons, and most of them are canons with reference to or in reference to consecrated life. 687, members who are exlustrated. Remember, a secondary reason of not feeling happy anymore with community life, but actually struggling deep within with what it means. So you have the motivating reason, and so you apply for an exlustration. And the canon says 687, members who are exlustrated are considered as dispensed from those obligations which are incompatible with their new condition of life. They remain, of course, dependent on and under the care of their superiors, and particularly in the case of a cleric. So when a cleric applies for an exclustration, that means you are distant, you stay outside of your community. Of course, you go to a diocese and you make sure that there's a bishop who receives you, and the bishop is informed about why you are on an exclustrated status. Anyway, and the point is, of course, they may wear the religious habit unless the indult specifies otherwise. So unless the permission specifies otherwise. So there are many sisters who go for exclustration and asked by the superior through that indult, means through that permission, you may not wear the habit, or better not wear the habit. So that's the meaning of indult, a sense of permission or authorization. And many of them, many canons on consecrated life pertaining to departure or leave of absence, use the word indult. Of course, 320 as one of the canon, the first canon there I mentioned, it also uses the word indult. Associations established by the Holy See can be suppressed only by the Holy See. So you understand that a mandated organization established by the Holy See can be suppressed only by the Holy See. Now, maybe, by way of, simple example, Knights of Columbus established by the Holy See can only be suppressed by the Holy See. And it uses here, something where the word indult is used. For grave reasons, associations established by the Episcopal Conference can be suppressed by it. So if the national or the Catholic Bishops Conference has established a mandated organization, the only competent authority that can suppress that is the Bishops Conference as well. The diocesan bishop can suppress those that it has established. So a diocesan bishop has established a public clerical association to become a religious institute of diocesan right. The same bishop who established that is the same bishop who can only suppress it. And also those which members of religious institutes have established by apostolic indult with the consent of the diocesan bishop. So you see the word there, apostolic indult. So apostolic permission, apostolic authorization, and so on. So it's a generic term for a favor for a person. It's a substitute for other concepts. It's frequently given to bishops or priests. So that's the word indult. You go to the next set of slides, set number 4, set of slides number 4. So I begin with that, the concept of juridical act. So juridic act. What is a juridic act? 19th century lawyers called pandectists developed the theory of juridic act. When they developed the theory of juridic act, in the mind of these pandectists, there is they focus on what they call the will of the individual as necessary to perform a juridic act. The will of the individual. Remember, there are two faculties, of course, in a person. You have the intelligence and you have the will. So it's not enough that you have the intelligence, but for this particular juridic act, it is important that there's also this faculty of the will of the person, the will of the individual. And juridic acts are distinguished from other acts. When you say other acts, of course, you're talking of because juridic acts have legal character, and because other acts have no juridic or legal character. When you eat, there's no legal character. Of course, now you begin to realize that most of the actions which we say are not juridic actions have become juridic actions because because of the consequence, they have a legal character. A friend of mine was to get married, and the fiancé ate in a restaurant, and the fiancé ate steak, and while eating, she got choked. She got choked because of this piece of steak, and unfortunately she died. So my friend lost a wife to be. So my friend decided to enter religious life. But anyway, my point is, the fiancé ate, and eating would have no juridic character, no legal character, but now it comes out like it has a legal character because eating, it happened in a restaurant while eating, and so investigations will have to be done for the simple reason that she got choked because of eating a piece of steak, and blah blah blah, and so on and so forth. Urinating is supposed to be, just to put the example like that, urinating is supposed to be an act which is not juridic. There's no legal character. It's the call of nature, and so you urinate. But then, in front of where you're urinating, it says, "Do not urinate, otherwise you'll be fined." So it has a legal consequence. So that act of urinating, So what my point is, of course, now there are actually what we would call non-juridic actions, but for one or another reason, they become like juridic acts. You urinate, and when you turn your, yourself back to the street, my God, unfortunately, you're bumped by a motorcycle and big accident. For heaven's sake, why would that happen to a person? So anyway, what the point is, juridic acts are distinguished from other acts which have no legal character. So there are actions with no legal character, there are actions which have legal character, and for that reason they are called juridic acts. Juridic acts are also distinguished from juridic facts. Facts that have legal consequences for which no will is required. And that's the point. Why I say there is what you call juridic act. Of course, because of the presupposition that this action includes or will focus on the will of the individual. But there is no action here. It is a fact, and yet this fact is a legal consequence. Birth, for example, death, for example, age, what is age? I'm 21, okay? And yet the juridic fact of being 21 has a legal consequence, or has legal consequences. So juridic acts entail two essential aspects. As I already mentioned, one, there is a person acting who has the will to do so. Remember what we were discussing in the other set of slides, where you have an infant below 7 years old, and not only that, you have an infant, not only does she has or he has age below 7, but that person is also incapable of personal responsibility. So he cannot be or she cannot be capable of performing a juridic act. So juridic act entails two essential aspects: a person acting, and a person acting has the will to do so. And the second essential aspect is the intention of the action is to bring about a certain juridic effect or consequence. Such consequence can affect oneself or can bind others. So you have the person and then intention of the action. We will still talk about that when I mention the canon, but just keep those two essential elements. And before I go to the canon, one more element, one more point with juridic acts. Juridic acts can be unilateral, they can be bilateral, they can be multilateral. So unilateral meaning it's issued by one person only. There are two persons in that juridic action, but the act is issued by one person only. So like the Republic of the Philippines with a standing pact or agreement with the State of the Vatican, that it should be the other way around. The State of the Vatican with a pact or agreement with the Republic of the Philippines, so that this unilateral access, that all marriages in the Catholic Church in the Philippines is also honored in civil law. That means it's honored by the Republic of the Philippines, by the civil government. So, in other words, if you're married in the Catholic Church here in the Philippines, you are also your marriage is also honored by the civil government of the Republic of the Philippines. If your marriage is annulled in the Catholic Church, it also is honored by the civil government, but not the other way around. Of course, not the other way around. So it's a unilateral juridic act, not the other way around, because marriages outside the Catholic Church are not honored in the Catholic Church. Okay, so a civil marriage is not honored in the Catholic Church. It will have to really pass through the reception of the sacrament of marriage to be honored as marriage in the Catholic Church. So you have also what you call bilateral juridic act, so which of course is issued by two persons, bilateral, mutual agreement, mutual pact. And then you have a multilateral juridic act. by many persons. So this example here is of course a resignation. You resign from office, you submit that to, you resign from office, and what? The board who received you, who accepted you, is the one who's going to approve your resignation. You resign from office, you give it to your principal. But your principal, to whom you resign, is not the authority is going to approve, is the board. Now you go to Canon 124. Canon 124 is the first canon that is in Title 7, which has a title juridic part. So it says, for the validity of juridical action, it is required that it be performed by somebody who is legally capable. So now you have the necessary elements for a valid juridic act. Remember, person placing the act has the will to do so. And then the canon continues, it must contain those elements which constitute the essence of the act. It must contain those elements which constitute the essence of the act. So the intrinsic nature of the act itself. The essence of the act, the elements which contain the essence of the act. When you perform the sacrament of matrimony, you must have those two persons who are going to perform the act of matrimony. You must have the exchange of vows, because that's intrinsic to the nature of the sacrament of matrimony. The exchange of vows, the exchange of I do's. Stop. That's 1 and 2. If you want to say the necessary elements for a valid juridic act. But Canon 24 mentions there must be some extrinsic formalities which could affect the validity of the act. And when you say extrinsic formalities, of course, that for which of course formalities which are required by law, and you can say, for example, extrinsic formalities in the sacrament of marriage. In the sacrament of marriage, a very clear example, and only in marriage, it says here, only those marriages are valid which are contracted, 1108, paragraph 1, only those marriages which are valid, which are contracted in the presence of an ordinary, local ordinary rather, or parish priest. Stop. It's only the local ordinary and the parish priest which could make for a valid marriage ceremony. But the law says here, it adds, or of the priest or deacon delegated by either the bishop or the parish priest. So if I officiate marriage in Sanctuario de San Antonio, the parish priest there will issue a delegation of authority, because in fact only the parish priest there is allowed to, as we say, be present, to preside, or to receive the matrimonial exchange of vows of these two persons. So that's what you call an external formality. And other elements required by law. Other elements required by law, you have, for example, when you need a black and white document, you need a signature. Okay? Black and white document needs a signature to be valid, because it has to be signed. How can you have a document, a document which is not signed? So there are of course provisions that stipulate that for this document to be valid, it must be signed. Now That's it. That's the necessary elements as I mentioned in that particular slide of Canon 124. Person placing the act, intrinsic nature of the act itself, extrinsic formalities, and other elements required by law. Presumption of law. What is presumption of law? Presumption of law, Canon 124, and that's what is there, paragraph 2, it says, a juridic act which, as far as external elements are concerned, is properly performed, is presumed to be valid. So the presumption of law is once this juridic act is properly performed, that it is valid. The important element here is, of course, there is a distinction between a manifested will and an intended will. Now, you talk of juridic act, it is a juridic act because there is a person who is capable of doing it, and that person capable of doing it is of course capable because he has the will to do so. And because he has the will to do so, the law presumes that once you've done it, it's presumed to be valid. Meaning, the intended will and the manifested will, they are one. Because in fact, manifested will, how do you gauge that? How do you gauge something which comes from within? In the exchange of marriage, in the profession of vows, when you face the court and say your thing there, the presumption of law is, of course, there is truth in your speech, because that's natural law. What we said in natural law, did we not say that it is natural law because it carries with it the essence of things? And the essence of speaking is speaking in truthfulness. So one good example, again, I take you to what is stipulated there in the canons of marriage. It says here 1101 paragraph 1, 1101 paragraph 1, the internal consent of the mind is presumed to conform to the words or the signs used in the celebration of marriage. So when a man says I do, or the woman says I do, when the priest asks, do you take him to be your loving husband for the rest of your life, and you say I do, or do you take her to be your loving wife for the rest of your life, and he says I do, the presumption of law is, of course, that's a real one. That's an authentic yes. When you profess your vows there, and you say I profess for 1 year chastity, poverty, and obedience, of course in the eyes of everybody is, you're not taking this for granted. You're not taking this for light or lightly. You're taking this for the way you really intend to live your life of consecration. Serious, no? But it always should give us a thought every time we go and witness a profession of vows, or every time we renew our vows, and now every time there is a perpetual of what you call solemn vows, or what canon law says, profession of perpetual vows. Perpetual is perpetuity, because there is always human nature that falls to that kind of error or whatever. But the point is, the presumption of law is very important. It no longer makes a distinction between manifested will and intended will, because as well stipulated in 1101, the internal consent of the mind is presumed to conform to the words that come out of your mouth. Precisely why there's what you call deficient acts, Canon 125. An act is invalid if performed as a result of force, enforced from outside in a person who was quite unable to resist it. Now, I just make it more generic because just to make an easy application of what is deficient act. It is not deficient act. It's a valid act if it is done, if it is placed knowingly or freely. Knowingly or freely, you would know that a person is capable of doing it. The person has the will to do so, and freely. And freely here means that it does not come with force. It does not come out of enforced fear. So you have two F's now. And of course, it does not come with fraud, which means deception. F, force, fear, and fraud. Of course, there are certain acts that may still be valid even though they are influenced by fear. But strictly speaking, here the law says, Canon 125, paragraph 1, as a result of force imposed from outside on a person who is quite unable to resist. So, any action done with such kind of force is invalid. And then your fear. Paragraph 2, an act performed as a result of fear which is grave and unjustly inflicted, or as a result of deceit, which I call fraud, is valid. So it can be valid unless the law provides otherwise. But very often when you examine the whole thing of enforced fear, when you examine the whole thing of deception, which comes through malice, deliberate concealment of facts or deliberate assertion of what is untrue in order to persuade someone to act, this thing can render an act invalid. In marriage, all this, what is force, what is enforced fear, which is fear, what is deliberate concealment or hiding of facts, which is malice or deception or fraud, they render an act invalid. In certain juridic acts, sometimes fear alone cannot render an act invalid. But that's why the point here of paragraph 2, it says there, unless the law provides otherwise. However, it can be rescinded by a court judgment either at the instance of the injured party or the party's successors-in-law or ex officio. So it can be rescinded by a court judgment. So you can always go and appeal yourself in court, and the court can say, can judge, in your favor. So, deficient acts. So we are with that deficient acts or those deficient acts. Many times, when you talk of force here, you are talking always of direct force or external force, or psychic force, or force that comes through chemical means, to the extent that altogether the will becomes totally absent because resistance is not possible anymore. So the act is no longer a human act. Okay. When you talk of fear here, individually enforced fear or indirectly exercised force so that the will is influenced by a threat of a severe evil, that act places under fear is valid. But again, the point of the act, it is valid, but it can be rescinded, especially if the fear is severe, external, unjust. and a cause for the manifestation of the will. Fear. What is that? Maybe I should leave that to you to think of something which action that can be influenced by fear and can render that action invalid. Maybe outside marriage, because what I said is when it is influenced by the 3 F's in marriage, the action is invalid. And fraud, very often, fraud, it being a deception, it being, especially when it is deliberate. What I said here, you hide facts from the person. By the way, when you go to marriage, the impediment of marriage is when you say impotency. If you hide that from your partner can take that as because it is an impediment. In fact, it is an impediment. Let's say, for example, you contracted marriage without you saying, or without you having talked that out with your partner. Easily, your partner would have asked the court to annul that marriage. But what I'm saying is, if you also desire, if you have talked that out with your partner and your partner agrees and agrees to marriage because you really love one another and you decide to live that in a state of companionship for life, the law will grant you or will agree to your. The law will not force you not to get married. So the law will agree to your desire to receive the sacrament of matrimony. And you have ignorance there, absence of knowledge. 126. An act is invalid when performed as a result of ignorance or of error which concerns the substance of the act and which amounts to a condition sine qua non. Sine qua non, a condition without which. So, if it is like, it's like a condition, if this condition is not granted, then I will not marry you, or if the condition is not granted, I will not make this act. So, of course, an act can be invalid or is invalid if it is, if it goes by that conditio sine qua non. So, when you talk of error, you talk of positive judgment, which is objectively false. That if they concern the substance of the action itself, absence of knowledge. What is absence of knowledge? Not just absence, mere absence, but for example, if you did not factor into the marriage the acceptance of the fact that children will have to come from that particular mutual relationship to one another, the generation of offspring, if you didn't factor that in your life together, I would suppose that because it affects the substance itself of marriage, why you desire to live this life together. So that can also affect the validity of the act, or that can render the act deficient. So deficiency can also come with collegial juridic acts. When you say collegial, that means college. That means a juridic act that is influenced by a group decision. So in order to place an act validly, it needs the consent of the group, or it can also be stipulated that this act needs the advice of the group. So that's why I place there as an example. Easy example, of course, is the consent of the council is needed to erect a building, or the consent of the council is needed to open a mission. So if the superior just opens a mission in Timbuktu without even without the consent, without the agreement of the council, of course you can disagree with the decision, and you can ask the superior to revoke the decision, because that decision needs the consent of the council. And there are certain decisions, you will see that in the stipulations, for instance in the Vadimecum, the guidelines for administration, provincial administration, general administration, you will see that which acts need the advice and which acts of which need the consent. Of course, one example is acceptance of a brother to the clerical order. Of course, the deliberations on that, on the acceptance, need the consent, because this is like, for a clerical institute, it's important that the council agrees to the application of this particular person for the clerical state, for the diaconate, and for the presbytery. In the same manner, I suppose for religious institutes, that any application for the vows need the consent of the council. What would need the advice of the council? Maybe advice of the council. Finances need the approval of budgets, need the consent of the council. So what would need the advice of the council? Do you have something like maybe an erection of a garage? Maybe that does not need the garage of a house. It does not need the consent of the council. Maybe that needs an advice of the council because it pertains to a budget within the ceiling. For example, within a particular amount already decided upon by the province, something like that. Anyway, the point there is to obtain consent or advice. Things are needed. Elements have to be respected. One, the group needs to be convoked. So the group that decides needs to be convoked, and the group that for which advice is sought, they must give their opinion sincerely, and they are to observe secrecy when the gravity of the affair requires it. So that's needed. Any decision that would entail consent or advice, the group must be convoked. The group individuals must give their opinion sincerely, and individuals must observe secrecy when the gravity of the affair requires it. For consent alone, it is needed that absolute majority that there is absolute majority, or absolute majority is needed for the validity of the act itself. And the superior here is bound by the decision. So, for example, you vote, 4 against 1 in favor of accepting this guy for perpetual vow. So, even though the superior has axe to grind against this guy who applies for perpetual vows, but it's 4 against 1, he has to accept the decision. So, because it's absolute. When you talk of absolute majority, that actually implies 2/3. And when you talk of simple majority, you're talking of 50 plus 1. So 50% plus 1. So to obtain advice alone, the group needs to be convoked or consulted, but the superior is not bound by the decision. Of course, you say this in the way law is interpreted, seeking advice. It's enough that you have sought their opinions. You have sought the opinions of the members of the provincial board, but as a superior, you're not bound by their decision. Yeah, you are not bound. That's how really the law interprets it. But according to me, and of course according to many canon lawyers, when you seek the opinion, you better respect the opinion. So of course you can still override it because it's only seeking advice. But altogether, according to me, if you seek the opinion of the group, it's better to go by the group's discernment, or to respect the opinion or the opinions of the group members. So that's all to say about deficient acts. You'll have to read the canon so that you will know more about it. Let me go to my notes. And did I say something about Simon Magus paying for a position in the church? Of course, something like that also belongs to the area of malice. So, of course, something like that, you can always say that the act is invalid. Definitely, it's invalid. So, deficiencies in collegial acts. Collegiality here is very important, because when you say collegial, you have the college of the group, so you respect the group. You have to respect the group's discernment. You have to respect the group's decision. 1 to 8, and that concludes the canons of Title 7, juridic acts. Canon 1 to 8, whoever unlawfully causes harm to another by a juridic act, or indeed by any other act which is deceitful or culpable, is obliged to repair the damage done. This is very important. This is very, very important. Especially nowadays, you're talking of, when you have to opinionate in public, or you are called for something serious to defend yourself, or you have to defend the state, or you have to defend the state of the institute, or you have to defend your community, and many things for that matter, but especially if you have to defend yourself. Repair of damage, that's a form of justice. The law would not be complete without that canon. And the law also says here, when you kind of say repair of damage as a form of justice, it requires restitution. When, for example, at the end of the day, one who is accused is not the one, or falls on the wrong person, restitution here means the restoration of the situation which existed before the marriage was done. Not marriage, before the damage was done. So again, it's the restoration of the situation which existed before the damage was done. So an object that was illegally possessed, return it. That's the form of justice. You say that also, I think, in the sacrament of reconciliation. For your penance, return what you stole. Of course, if you stole billions, I wonder how you're going to return them. So that's the matter of graft and corruption. But the point here is, damage to a person, to an institution, is done through, if you have to repair that, is done by way of restitution. You have also by way of reparation or satisfaction, be this financial or moral. A Christian faithful can legitimately defend or vindicate their rights. So a person damaged by an administrative act could make recourse to hierarchy. For example, You just didn't feel good. You felt offended by a document, by the rescript of an administrative act of your superior. You can always go to the higher authority. But why not? Always make recourse to the hierarchy. You need, if you really feel the need to do so, because you felt that by that you were, you're damaged by that administrative act. Precisely why there's always what you call in procedural law. Procedural law provides for norms that requires, norms that pertain to actions for the repair of damages. There is always an appeal, a recourse. That's why there is a court of appeals. That's why there is a higher court. And you keep, there was, for example, an employee of an institution who was demoted for lack of sufficient reasons. She felt offended by the demotion, and she brought the case to civil court. This is in a Catholic institution, and in the court of first instance she lost her case, but she still felt that she has to move on to the appeal and appeal to the higher court, and the higher court did not decide to her favor, but she moved on to the highest court, the Supreme Court. My God, lo and behold, she won her case, and the Catholic institution was obliged to pay her, I think, at least $1 million, if not $2 million, for the damage done. So an act of justice. Of course, we mentioned something in the first canons there, when we were talking about when we were trying to understand law, and we were trying to put that in the context of equity, and one realizes, especially pertaining to the authority, one realizes that it's an act of humility if on your way to court you realize that it was really a mistake, an error on your part. So better settle with that person as subject to you. Then it solves the whole thing. That's the most evangelical, on top of it being an act of humility. Should I leave it at this? Maybe just quickly, and when you put me off, or when you put this off, quickly, you just kind of cite. I'm more concerned with those deficient acts, them being deficient because of force, because of fear, because of fraud, because of error, because of ignorance. Now, with those 5 elements, can you just give me an example? An example that deals with an act being deficient because of force. Of course, you will just say a bride being forced by the parents to marry this man. Of course, that renders an act invalid, but something related to that. And then fear, but you have to really understand it in the context of a canon. And then enforced fear. And then fraud. That's easy when you talk of deception, when you talk of malice. And then error, and then ignorance as absence of knowledge. And hope to see you face to face next meeting. That's November 10. I will conclude everything of the first book next meeting, and I will already introduce the next subject related to the second book, because there will be a lot of things there, and that will also give you a lot of readings related to the second book, because we talk of many things there, part 1, which is the Christi Fidelis, Christ Faithful, part 2, which is the hierarchical constitution. Of course, we are talking of institutions you know very well, but we just need to know more as according to how the law has articulated things for them. And of course, we talk about Institutes of Consecrated Life in part 3 and Societies of Apostolic Life. So that's all for today. I hope I'm clear. If I'm not clear, of course, there is always the email, and next meeting there's always the chat side of the face-to-face synchronous presentation of the course. Thank you. Glory to the Father, and to the Son, and to the Holy Spirit, as it was in the beginning, is now, and will be forever. Amen.